Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured workers. It's Mike Cardamone here, and today I wanted to talk about stamina. And what I mean by that is when a witness, and in particular an injured worker, is testifying, they may not be used to the rigor of dealing with focusing for an hour, sometimes 2 hours, and answering questions non-stop. And so stamina becomes really important. And where I see this coming into play most often is during cross-examination. So if we're taking the deposition of an injured worker, we're going to go first, meaning I'm going to ask my client in questions. It's called direct examination. And the other side is then going to cross-examine the injured worker. And a lot of times I can see our clients getting tired. And what happens as a result of fatigue is they start getting a little bit short or a little bit lazy with their answers. Maybe they're daydreaming about, just being home at night and going out to dinner that day, or, a certain family function or happy hour or whatever the case may be. And they start trailing off a little bit with their focus. That can really damage a case. Here's an example that I tell a lot of my clients. The other attorney will often go through a whole litany of ADLs, what we call activities of daily living. And they might ask our client, "Sir or ma'am, can you dress yourself, bathe yourself, do dishes, do chores around the house? Can you drive? Can you get your mail? Can you put your trash cans out?" Things like this. And at that point in a deposition, it might be 45 minutes in, an hour in, maybe even more. And sometimes you can see the injured workers just starting to fade a little bit. And sometimes they'll just start answering questions quickly. They'll say yes, yes, yes. And one time a client who had a neck injury, she was asked whether she could drive. And the attorney was going pretty fast in that whole litany of ADLs. And she said yes. And then after the deposition was over, she said, "Mike, I don't really drive much anymore because my neck hurts and I can't turn it all the way to be able to look properly. And it's kind of dangerous. So I only go a couple miles if I really have to, but no further than that." And I said, "Well, you didn't say that on the record. What you tell me is not evidence." So I use that as an example for clients to really keep their focus. And it's okay to answer a question with, "Can you please slow down a little bit? I can't, my brain doesn't operate that quickly," or really think about the question before answering it. And even if you have to pause, it's okay to say, "Yes, I can do this, that, or the other. However, I do it now with pain because of my injury," or "Now it takes me longer to dress myself," or "Now I pay the price when I drive," or "Now, I do things, but I do it with the help of others." So it's really important for injured workers to understand that you don't always have to answer yes or no in a black or white fashion. You're allowed to explain yourself and say, "Yes, I can do this, however," etc., etc. So it becomes really important to prepare your client for these kind of things and to tell them that they need to keep their focus. If they need a break, it's perfectly fine to take a 2-minute, 5-minute break for some water, or to use the restroom, or just to collect their thoughts. So stamina becomes really important. And I'm sure this doesn't just apply to workers' comp, but other types of litigation as well. So it's really up to the attorney to give your client a heads up about these issues and to practice so that they can handle the questions properly and be able to explain that not everything is black and white. So I think this is really important. It comes up very frequently. If you have any questions about this topic or anything relating to workers' comp, always feel free to call us. It's 215-206-9068. You can find us online at cardamonelaw.com or myphillyworkerscomp.com. It's the same website. And you can also email me directly if you'd like. Michael, Michael, at cardamonelaw.com. So Michael at CARDAMONELAW.com. And I'll be happy to help you out. We always give free consults. We never get paid in workers' comp unless there's a court order, which means there has to be either litigation in our favor or a CNR, a compromise and release agreement, a settlement. So you can get free representation and set your case up, and we tend to double or triple people's money. So if you don't have an attorney, call us, and we'll be happy to help you out, whether you're in Philadelphia, the middle of the state, Pittsburgh. It doesn't matter. It's the same law that applies. So we'll talk to you again soon from Cardamone Law University. Thanks.